right, welcome to this edition of Sports in the Courts. I am your host, Tod Castleberry, president of BLC Digital Strategies, and I am joined by our legal analyst, Mr. Charles Bonani. Charles, welcome.
Hey, Todd. Great to be here.
Yeah, I got to tell you something. Today's topic is very complex. We're going to try to break it down as simplistically as possible so everybody can have an understanding of what is the new college sports landscape for Division I athletes. 2 weeks ago, Judge Wilkin, she actually finally made the ruling with the lawyers representing all Division I athletes and the most powerful conferences, and it ends 3 separate federal antitrust lawsuits, which the NCAA was illegally limiting the earning power of college athletes. So amateurism kind of bye-bye, gone. So let's get into what the new ruling means, and starting July 1st, the new era of college sports. Charles.
So, this was the long-awaited final approval of the House settlement. We, of course, were in the studio a couple months ago talking about the preliminary approval that had been granted for the settlement, and then the final approval hearing that had taken place after a little bit of back and forth with the parties and some consternation from the judge and some additional final tweaks to the settlement. It has now been finally approved, meaning this long-awaited brave new world, if you will, of college sports is upon us. And so what does that mean? That means that starting July 1, universities will be able to formally start paying student athletes as part of a revenue sharing system and
a salary cap.
With a salary cap. And so essentially college sports going forward now is operating under a salary cap system similar to that which exists in professional sports, but with a lot of differences.
A lot of differences.
Given the college
there is
sports
no
landscape.
collective bargaining agreement that they are covered under. And to back up, the $2.8 billion in back damages that were awarded to athletes who that's going to be paid out over the next 10 years for college athletes from 2016 to the present day.
Yes, and so as we've talked about the last time we were here, there are 2 different components to this settlement agreement. There's the backward-looking piece and the forward-looking piece. The backward-looking piece is back pay. It's a damages payment to athletes between 2016 and 2024. Since the final approval of the settlement, things move fast in the courts. That has been appealed already, and so the damages portion is currently on hold. And so we will not be focusing on that for
Don't
today's
need to
discussion.
dwell on that because that's a historical, as you said, going backwards. We're here about the now, and how does this affect my college football team, damn it.
That's what matters the most, of course. But so what is important to note is that the forward-looking piece, the new revenue-sharing model, that is not delayed or paused or stayed while the appeal of the final approval goes through. And so this new world is upon us. It is happening. And, all the parties involved are going to be now operating under this new system going forward. So even as there's, an appeal that plays out, like this new system is in place, the train is running and moving down the tracks. And so, we want to kind of break down what all that means.
Yeah, and for starters, and the slides you see up here that we're going to be presenting throughout, this is coming directly from the new College Sports Commission that is going to be taking over a large chunk of this, and frankly, the NCAA could never enforce the rules. That's why this was created, and they're going to be heavily involved. So let's talk about the College Sports Commission.
Yeah, so what's key to note here is that prior to this settlement, the NCAA was, judge, jury, and executioner, for lack of a better term, and, all of the NIL rules and the way, disputes under those rules and and just the entire governance of student athletes with universities was run by the NCAA. Now, the NCAA still has heavy involvement here. They still, are creating rules to govern the way in which, universities operate with student athletes. But what the settlement did is it created this College Sports Commission, which is supposed to be this independent body to basically be the regulatory body for NIL deals between universities and student athletes. And so what it does is for all NIL deals over $600, student athletes and universities are required to report that through this College Sports Commission. And then there's a whole multi-step process with factors to consider whether or not it's an approved or not approved transaction.
And market value. And so much of this it's going to be fascinating to watch how this plays out. You said the threshold is $600, right? Versus guys that are getting $60,000 versus guys that might be getting $600,000 versus a couple of guys are going to get millions, as we've seen. And they're going to try to benchmark it as, is this for real? And the other part of this is taking out the collectives and the boosters in that particular process.
So that is the most important and, to me, interesting part of all of this, is that is essentially what this is designed to do, is regulate these so-called booster, endorsements and then, direct payments to athletes. So I'm kind of referring to this as the booster commission or the booster rule,
right?
Because boosters under this new settlement, they're defined as associated entities or individuals. That's like the magic words that are used. But what we're really talking about is boosters and collectives, is these organizations that anyone who follows college sports will be familiar with, that are the ones paying the NIL deals to these students. And basically, the way a lot of people view it is just complete pay to play.
No question.
For lack of a better term. And so what the NCAA wants to do is they want to separate out what they've, or now the new College Sports Commission, through the NCAA negotiating this settlement, what they want to do is separate out the legitimate deals with boosters versus deals that are considered under this new system to not be legitimate, as well as deals with third parties that are not considered boosters.
So there are, and that's just it, because there are different pots of money that athletes can be compensated now, starting with a salary cap of, they estimate at $20.5 million to the universities that they can disperse to athletes as they see fit. That's also what this CSC is going to regulate. They're going to make sure the athletic departments aren't over the cap, and they're in that business too, pretty much like a union, if you will, to make sure that everybody's playing by those same rules, and NIL payments outside of what that factor is, because you could, beside from NIL, you could still have another deal from a collective or a booster, not to the same degree, but the scrutiny is there. It's going to be fascinating to see how this manifests.
So you have now, you mentioned the salary cap. So that's going to be $20.5 million per university, and that is calculated based on an average of revenues across the D1 Power 5 schools. But that is the salary cap for schools that are going to be part of this new system going forward. And so there's that salary cap, there's that pot of money, and then there are these separate third-party endorsement deals that the athletes will be able to get. And so what this College Sports Commission, it's also being referred to, as a clearinghouse for reviewing all these payments. What it's going to be doing is basically trying to make sure that the salary cap is actually a salary cap. So like in professional sports, teams have salary caps, and there are prohibitions on
you have to have a
teams,
capologist to manage it correctly.
And there are rules preventing teams from circumventing that cap to basically,
Fines
arbitrarily.
and draft picks, et
Right.
cetera, et cetera.
Now, of course, you see all these professional athletes, they have $1 million endorsement deals. They are in commercials. They are clearly making money outside of their salary with the team, and that's completely okay. And that is basically the system that college sports is trying to implement here. What they don't want to do is have the schools with the significant booster resources to basically say, okay, you're going to get a $500,000 salary under the $20.5 million salary cap that we have, but here's a nice $10 million deal on the side. Now, a lot of people listening might be a little cynical and think, yeah, that's exactly how this is going to work going forward. That's where we'll see how the enforcement plays out. But what's important to note is that there's this new system in place that previously didn't exist for an entity to actually determine whether or not these deals
Are
are
legit.
valid or invalid. And so I don't know if you want, now we can get into sort of like what those factors are that they're going to be looking at.
Yeah, and as I saw a quote from one college coach, and it was a great, and he goes, seems like just the other day, if I gave a kid a ride across campus, that was a violation. He goes, now we can give him a Lamborghini and everything's going to be just wonderful. Transparency, it's out in the open, which is a good thing. It's going to be interesting to see if these enforcement procedures, before we get into that particular part, one of the things that also is part of the settlement was limits on scholarships and the rosters.
Yes.
So that was another key point. So schools must now abide by various roster limits for each sport in place of scholarship limits, which again, people still take for granted. Scholarship, that's your room and board tuition, and has a lot of value with the cost of college today. This is all outside of the original scholarships that they're getting and student aid and that type of thing.
Yeah, the scholarship piece and the removal of that in place of roster limits, that was actually one of the main pieces that held up the final approval of the settlement, because there were a lot of there were a lot of students that were objecting to the settlement on the ground that they were going to, under the settlement, they were going to lose a scholarship that had previously been offered to them. And what ended up being agreed upon essentially was a general system of grandfathering in, or basically allowing schools to keep those like specific set of individuals that happen to be waiting to start their scholarship with their school as the settlement came down, to allow them to maintain their spot, to basically just prevent anyone from being harmed by and adversely affected by the settlement. Because remember, I mean, this is it was a class action of these student athletes, and this is a settlement between the athletes and the NCAA and the conferences, and so there's some give and take. But of course, the interest of the athletes is important.
To that point, that by eliminating scholarship limits, they estimate that this could actually create over 115,000 additional scholarships annually. That's a big deal.
Yeah, and
that's a big number.
because the roster limits are now changing, and so I think it still remains to be seen how this actually plays out. And I think I'm a little skeptical that it is going to harm and be like more harmful to student athletes and cause them to lose more opportunities. Like I'd probably fall more in the position of what you just noted, that there's going to be actually more scholarship opportunities that can be given out.
Right. All right, Charles, let's get into the specifics, because the College Sports Commission and all this into effect, they are moving fast and furious, systems in place. And we're going to walk people through some terms that you are going to be hearing that are the key terms and what this all means. So the right here, and again, you can go to the website now. It's very comprehensive. So arbitration. Talk to us about exactly what this now means
So you'll recall earlier in this conversation, I was talking about how now there's this independent enforcement mechanism separate from the NCAA, and that is arbitration. So that's what the arbitration is. And so as the definition provides there, that is an independent dispute resolution process that will be provided for athletes who want to contest an adverse decision about their NIL deal. So if they are reporting an NIL deal and the commission comes back and says, well, this is actually, with an associated entity or individual, which remember, that's a booster. This is with the booster. And so because it's with the booster, it has to meet X, Y, and Z requirements, be for a valid business purpose. We determine that it is not. And so your NIL deal is rejected. You can't get this money.
Okay.
The athlete then can say, well, you're wrong. I disagree. I'm going to go to arbitration. And then you have an independent arbitrator that handles that process. That is important because previously it would just be the NCAA getting to decide that. And so part of what was key about the settlement is that in theory, now you're going to have a much fairer way of resolving these disputes.
Okay. Key point, because again, this is where the NCAA was overwhelmed. They weren't equipped to what has the growth of major college sports. A clear deal, which ties in to NIL and the cap system, which the next two.
A clear deal is exactly what it sounds like. It's a deal that's approved by the commission, and you'll see there that there's a reference to NIL Go. That's just the name for the actual reporting system and reporting database that student athletes are going to be able to use. And on this College Sports Commission website for the student athletes out there, there is a link to go and register for an NIL Go account. So that is how those deals will be reported. And so,
and it's
yeah.
The NIL and that system in place too. It's comprehensive. Basically, every deal has to be approved. The athletes are responsible. Athletes are going to have agents. They're going to be responsible for submitting this so that these deals get cleared. They get red flagged. They get whatever. So that system is in place and will start happening immediately.
Yeah, and to that point, I mean, that's where sort of like the business of this really kind of comes to a fold. These athletes are going to be having, attorneys, agents, other representatives that are going to, be monitoring that and ensuring that all of that is done appropriately. And, with this new system, that's going to be more important than ever.
So on the cap system, an outside firm called LBI, they created a software portal, college athlete payment system, which is CAPS. This is going to be for managing roster spots for every sports, tracking cap allocations of the overall 20.5 million figure,
Yep.
and monitoring payments going to athletes.
And so just on that, just like the student athletes have reporting requirements, the universities have reporting requirements. And so that's what that is.
Okay. A not clear deal is the exact opposite of a clear deal. Do not collect your $600, do not pass go, and you got to get clearance.
Yeah, that one's a bit hard to figure out. So glad we were able to break that code.
Opt-in institutions.
So opt-in institutions, this is something we haven't discussed yet, and this is a particularly interesting one. It is referring to the universities that are not actually members or parties to the original litigation. So you'll see there it's referencing all of the Big Five conferences. It was the NCAA and those Big Five conferences that were the actual defendants in the lawsuit.
Schools do have options if they choose not to participate.
So the way it works is those universities under the Power Five conferences are essentially automatically opted into this deal by virtue of being parties to the settlement. All other non-Power 5 schools have the option to opt in, and that is what that refers to.
The payor, that is the entity or individual providing NIL compensation to a. So you got Johnny Car Dealer.
Yeah, that could be a company.
Which then
Any sort of
ties
brand
into the
product.
range of compensation, where this is fascinating to me. This clearinghouse will determine if somebody's offering student athlete $1 million, what does he have to do for that $1 million? Mm-hmm. Is it lip service? Is it memorabilia? What is that? And they will compare it against, from social media influencers to professional athletes. Is this fair market value versus they're just giving them $1 million just because they can?
So yeah, my prediction. This is quite a pretty standard prediction in this sort of realm. But I think this will be the area that creates the most disagreement and consternation about how it's actually applied.
Yes.
Because you have, I believe it's an algorithm that's been created to determine what is an appropriate range of compensation. And, the way you saw in that definition, the way it's defined is whether the compensation being offered is comparable to that of a similarly situated individual. Mm-hmm. Mm-hmm. And so, we are all just left to trust the algorithm that they entered in the right data as to what is and isn't similarly situated for that number to be able to be produced. But as the old adage goes, the
you're worth as much as what anybody will pay you. But for here, they're trying to legitimize and saying, well, okay, but you're trying to take out some of the absurdity because, take, for example, Arch Manning down in Texas, right? He's barely played. You know how much money he's raked in and by committing and going there with him barely playing and what the future looks like? So what is he doing? Because it's not on the field as an example of, is that fair? Who's determining what's fair because of his brand and the power that he has, not only with his family and the hype coming out as the #1 quarterback in high school?
And one last piece on that is that it's the range of compensation, but then there's also the valid business purpose. So there are these two main factors to consider of whether a deal is valid or not. And the valid business purpose, the way the College Sports Commission is defining it, and this comes from the settlement, is something that is selling a good or service to the public for profit. So basically a legitimate endorsement. But again, that is of course very subjective and up to interpretation. And so moving on from that, the next term that we have here is revenue sharing cap, and that just refers to this $20.5 million figure that we have been talking about, which is the salary cap.
Right. Okay. And that goes up X amount of percentage each year.
I believe it's estimated to go up about 4% each year.
Okay.
Over the 10-year period of this settlement.
Moving right along, the College Sports Commission. They are what we kind of open up this entire conversation about, and what the differentiator is for what the NCAA will continue to focus on, as you said, is kind of like the rules of the game, if you will. And let's face it, the main part of this College Sports Commission is football, basketball, and women's basketball are the top three sports that are going to be dominating in this scenario.
Yes, and so that is a key point to note. Then you essentially then have 5% to go towards all the other sports, which I think it'll be interesting to see how that kind of plays out and how that kind of affects the other sports. But that is, the distribution that we have, which is, commensurate with the revenues that.
And that's supply and demand of who brings in the revenue, and based on TV contracts and the pile and the pots of money from ticket sales and the entire pot of money. Designated student athlete, that's pretty self-explanatory. And the biggest part that we already discussed is there are no scholarship limits, and that was a big part of the deal to create more opportunities for student athlete. Name, image, and likeness, person's name, nickname, picture, portrait, blah, 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 blah. Just spelling that out and as to the expectation in NIL Go.
That's the portal.
Run by Deloitte and the College Sports Commission. Yep. And the gentleman that's heading up the College Sports Commission is based here locally, just came from Major League Baseball, executive there for many years. Let's carry on here to the roster limit.
Yes. So, I mean, that is what, we were talking about before, which is replacing the scholarship limit, which you'll see in the below definition. Made clear that, scholarships are available to anyone on the team rather than a, hard cap on scholarships as it was before.
Roster limit and scholarship limit, straightforward. These are the exact definitions that they are using on the website. We've discussed that. Valid business purpose.
So I just brought that one up. That's what I'm very interested in. That is part of the really two-factor test for whether an NIL deal is valid with the range of compensations. You have valid business purpose, range of compensation. And again, that is, just trying to make sure that these boosters and collectives are,
playing by the
providing
rules.
some sort of, actual exchange of services. And so, the student athlete is not just getting a paycheck from this booster, but they are promoting something of value. And now, will these boosters and universities find creative ways to get around that? I'm sure, not to, again, be a cynic, but I think it's just a reality that whenever you have a new system in place, some of the more competitive players are going to be looking for creative ways to circumvent that.
There's a will, there's a way. It's going to give us more transparency. You will know how much these college athletes are getting. It was always been rumored that Arch Manning was getting this, Shadur Sanders was getting this, Travis. It was always rumored with no official confirmation. It's going to eliminate that. And that's a big part of this and bringing in these systems. And they're not messing around. When you're bringing in the accountants, you're bringing in the attorneys. It's a new day.
And I think a key point to note here again is all of these, now pretty seemingly stringent requirements on what is and isn't a valid NIL deal. This only applies if the deal is with an associated entity or individual. Mm-hmm. And so I think, part of the reason why the settlement was approved from an antitrust and free market standpoint is that third-party NIL deals that do not involve these associated entities or individuals are completely free reign. So they will not be regulated. So they're the way I understand it is that there has to be this sort of threshold determination of an associated entity or individual. And then that's where ensuring that it is a legitimate deal comes into play. But for all their third-party deals, if some guy wants to, do an endorsement deal with Quiznos over, in Kansas, and they're an athlete in for some California
right. How
university.
can you impact that versus? Yeah.
They're probably not an associated entity or individual,
Well, and we're not even going to get into the notion of transfer portal. What if I leave? What if I get hurt? What if the complexity of things that still need to be sorted out. We will be staying on top of this. It is here July 1st, and I think it's good. It's gonna take some time to make it better, but let's face it, the college athletes they've been getting ripped off for years, and it's good to see that this is the next iteration.
Yes.
All right. Well, thanks for joining us today. We will keep you posted on this and other sports in the courts.